Welcome to County Portal, your simple source for local government services and public records. Let's get started.
What does it really mean when a case is marked as closed? It's a term you see on TV shows and in legal documents, and it sounds very final, but its actual meaning can vary a lot depending on the situation. In the simplest terms, a closed case means a court or an agency is no longer actively working on that specific matter. The file has been taken off the active pile, but that doesn't always mean it's locked away forever. Let's break down what this status means in a few key areas. First, in the world of criminal law, a closed case can signify several different outcomes. It could mean the defendant was found guilty and has been sentenced, bringing the court's proceedings to an end. It could also mean the exact opposite: the defendant was acquitted, or found not guilty, and is free to go. A criminal case can also be closed if the prosecutor decides to drop the charges, which is officially called a dismissal. This might happen if new evidence comes to light or if a key witness is no longer available. Finally, a case is closed after a plea bargain is accepted by the judge and the sentence is handed down. The important thing to remember is that closed simply means the legal process for that charge is over. It doesn't automatically imply guilt or innocence. Next, let's look at civil cases, which are disputes between people or organizations, like a personal injury lawsuit or a business conflict. When a civil case is closed, it typically means a final judgment has been entered. This often happens after the parties reach a settlement agreement out of court, which is how most civil cases end. They inform the court of their agreement, and the judge officially dismisses the case, closing the file. It can also be closed after a trial where a judge or jury makes a final decision. Even though the case is closed, one party might still have to take action to collect money awarded in the judgment. The term also applies to administrative cases with government agencies like the IRS, Social Security, or Child Protective Services. A closed CPS case, for instance, means the investigation is complete. It could be closed because no wrongdoing was found, or because a safety plan was successfully implemented and the agency's involvement is no longer needed. So, the big question is, can a closed case ever be reopened? The answer is yes, but it's difficult. To reopen a closed criminal case, there usually needs to be compelling new evidence, like DNA results that weren't available before. In civil cases, it's very rare and usually requires proof of fraud or a major error in the original process. For administrative cases, there are often specific appeal procedures that allow for a review of the decision, which is a form of reopening the matter. In short, case closed is a procedural status. It marks the conclusion of the active phase of a legal or administrative proceeding. It's the end of that chapter, but under certain, specific circumstances, the book might be opened again. Thanks for watching, and I hope this explanation helped clarify what a closed case status really means. If you found this information helpful, please hit the like button and